Hello viewers and students. I welcome you in second part of authorities under the Industrial Dispute Act 1947. I welcome you in my YouTube channel at lecture series on labor laws first. So students, in this lecture we are going to discuss the remaining part of authorities under the Industrial Dispute Act 1947. So we were discussing the authorities under the act under which we have discussed the first authority works committee, the second authority conciliation officer, and third authority, that is board of conciliation. Now we are going to discuss the fourth authority, that is provided by section 6, that is court of inquiry. So friends, the purpose of court of inquiry or the constitution of court of inquiry is to study the causes of industrial dispute. Basically, this is the reason, this is the purpose for which the court of inquiry is constituted. So whenever any dispute arises, so what are the causes, what are the reasons for which the industrial dispute is arise, that has to be studied. So for that purpose, the appropriate government may constitute the court of inquiry by notification in official gazette. The the appropriate government shall constitute it. The composition of court of inquiry shall be, it may consist one or more persons. The appropriate government will decide what shall be the number of members in court of inquiry. Again, the appropriate government shall have power to decide the qualification of persons appointed at court of inquiry, their jurisdiction, their salaries as it thinks fit. Now we must see what are the powers of court of inquiry. See, you can see the powers of court of inquiry. It doesn't give a specific power. Section 6 of the act doesn't provide the specific powers of court of inquiry, but it just makes a reference towards the powers of board of conciliation. So the court of inquiry can exercise all the powers of board of conciliation for the purpose of investigation and inquiry of industrial dispute. The duties of court of inquiry. The court of inquiry is the fact-finding agency or the body. As while discussing the purpose, we have discussed this body is constituted to study the causes of industrial dispute or the reasons for the industrial dispute. Therefore, the court of inquiry shall inquire into the matters that are referred to it. Whatever the dispute that is referred to it, that dispute should be studied. The proper inquiry shall be carried out by the court of inquiry to know the reasons of the industrial dispute or the causes of industrial dispute. It is responsibility of court of inquiry under section 6 to submit such report to appropriate government within 6 months from the date of a reference. So when the matter is referred, from that date, within next 6 months, the court of inquiry has to conduct the inquiry and submit its report to government, by which government can take the decision on its reference for adjudication. Then next authority is the labor court, which is provided by section 7 of the act. See, as you know, the Industrial Dispute Act gives first preference to modes of dispute settlement, modalities of dispute settlements or the modes of dispute settlements through discussion, negotiation, conciliation, etc. And when such dispute is not solved by above authorities, then government can refer such dispute for adjudication. And what the authorities, now we are going to discuss, all these authorities are adjudicating authorities. In earlier authorities, the authorities were not going to take the decision. The decision has to be taken by parties themselves, and the authorities like the conciliation officer, board of conciliation, they have to play a role to mediate and to help the authorities to solve the dispute. But now these authorities are going to take the decisions on the dispute. So this is the first authority. So The labor court shall be constituted by appropriate government by notification in official gazette. So it shall consist a person appointed by the appropriate government. It means in labor court there will be only one person who is going to work as a presiding officer of labor court. What shall be the qualification of the person who is going to be appointed at a labor court? That person should possess the following qualification. The first qualification is he is or has been the judge of high court, or he is or has been the district judge for not less than 3 years, or the person who has held any judicial office for at least 7 years, or he has been presiding officer of any labor court. So this is the qualification. It means the person who is going to be appointed as a presiding officer of labor court must possess these any of these qualification. Now we are going to discuss what shall be the powers of a labor court. See, the labor court can enjoy all the powers of court of inquiry. See, as we discussed while discussing the powers of court of inquiry, we have discussed that the court of inquiry can enjoy all the powers of board of conciliation, conciliation officer, etc., for the settlement, investigation and settlement of industrial dispute. Similarly, here also the labor court can enjoy all the powers of board of conciliation. So friends, the labor court can enjoy all the powers of court of inquiry here, that is necessary for investigation and settlement of industrial dispute. So it has status of civil court. The court of inquiry is deemed as civil court under Civil Procedure Code 1908. It has power to fix the cost of any proceedings before it. So the labor court can conduct the proceeding before it and decide the cost of such proceedings. It may solve the dispute, it may inquire into the dispute, and it may give decisions on the dispute relating to illegality of strike, withdrawal of any concession, dismissal of any workman, etc. Now we have to see what are the duties of labor court. See, the labor court must perform the following duties. Where any dispute is referred to labor court, it is the duty of labor court to hold the proceedings for the inquiry and the settlement of such industrial dispute. The labor court must give an award. It means after completion of inquiry before it, after completion of proceeding before it, it shall give the final decision on such dispute, and such dispute must be submitted to appropriate government within a particular time limit, and this time limit is 90 days from the date of reference. It means the labor court must submit its report within 90 days from the date of reference of dispute to such authority. Then next authority under Industrial Dispute Act is Industrial Tribunal. Section 7A of the Act deals with the constitution of Industrial Tribunal. The constitution of Industrial Tribunal shall be done or shall be made by the appropriate government by notification in official gazette. It means section 7A of the Act empowers central appropriate government to constitute industrial tribunal by notification in official gazette. The composition of industrial tribunal shall be the only one person. A member shall be appointed as a presiding officer of industrial tribunal. Then we must say what shall be the qualification. What is the qualification for the appointment of any person as the presiding officer of industrial tribunal? The person who is or has been the judge of high court, that person must any of the following qualifications, like a person is or has been the judge of High Court, or the person who is or has been the district judge for not less than 3 years, or the person who has held any judicial office for at least 7 years, or the person who has been the presiding officer of any labor court. Such persons can be appointed as the presiding officer of industrial tribunal. Now we must see what are the powers and duties of industrial tribunal. The powers and duties of industrial tribunal shall be same as the powers that are exercised by labor court for adjudication purpose. See, it means the industrial tribunal has very wide power. It can exercise all the powers, including powers of conciliation officer, powers of board of conciliation, powers of court of inquiry. It can exercise powers of labor court also. So whatever the powers that are necessary for the inquiry and settlement of industrial dispute and for the adjudication of industrial dispute, such powers can be exercised. So generally the industrial tribunal shall hold the proceedings, and for such a proceeding it shall follow the principles of natural justice for the adjudication of matters that are referred to it. So it shall adjudicate the disputes relating to matters that are mentioned in Schedule 2nd and Schedule 3rd of the Act. These matters are like to check the legality or illegality of standing order, to see the application of any standing order, to check the legality or illegality of any dismissal of workman, to decide the dispute relating to wages, modes for payment of wages, period of payment of wages, allowances, hours of work, intervals, leaves, holidays, retrenchment of workman, closure, etc. It means say the industrial tribunal has very wide power to decide various kinds of industrial disputes that are specifically mentioned in a Schedule 2nd and Schedule 3rd of the Act. So regarding that, there is case law in Brookband India versus YK Gautam, where the Supreme Court considered the power of industrial tribunal to decide the industrial dispute, and the court held that the services of probationer, if such are terminated and if any dispute arises due to the termination of services of probationer without giving a notice, such dispute also can be decided by the industrial tribunal, and the court held that the industrial tribunal can check the validity of termination order that is issued by the industry. So these are the powers, and now we are going to discuss the last authority under Industrial Dispute Act, that is the National Tribunal, that is constituted under section 7B of the Act. So the purpose of this constitution of National Tribunal is to adjudicate the disputes of national importance. So those disputes which are important from the point of nation, such dispute shall be referred for its adjudication to National Tribunal. The Constitution, the central government shall constitute the National Tribunal for the adjudication of any matter that involves the matter or issue of national importance. If the central government is of opinion that any dispute involves the question of national importance, the central government may constitute National Tribunal. Or if government is of opinion that such dispute involves two or more states, or if government is of opinion that it may affect two or more states, in such circumstances central government may refer such matter to National Tribunal for its adjudication. The composition: the National Tribunal shall consist of only one person, only one member, who shall be the presiding officer of National Tribunal. The qualification: the person who is or has been the judge of High Court can be appointed as the presiding officer at National Tribunal. Now we have to see what are the powers and duties of National Tribunal. The National Tribunal shall exercise the following powers and perform following duties. See, all the powers which are vested with Industrial Tribunal, or all the powers which can be exercised by earlier authorities, that can be exercised by National Tribunal for the purpose of adjudication proceedings for the settlement of disputes. Then it can decide and provide the wage rates for in industry. It can decide the matter relating to increase of wage rates. It can give suggestions to central government whenever it is called for. So friends, these are some authorities under the Industrial Dispute Act. So these are the 7 authorities which plays very vital role in investigation of industrial dispute, in settlement of industrial dispute, or in adjudication of industrial dispute. So friends, if you like this video, please like it, share it with your friends, and don't forget to subscribe my channel. So friends, thank you.